Everybody, welcome to the 15th episode of the Futureworlds Metaverse podcast. Today's episode, ladies and gentlemen, Stephen Masur, who is a IP attorney. He's kind of a Web3 metaverse attorney. He's an all-around attorney based in New York, but I see him in Austria. I see him in LA. I see him in all parts of the world. Welcome to the show. Thank you for hopping on extremely short notice, about 4 minutes, ladies and gentlemen. That's how long it took us to connect.
Well, thank you for having me. I'm really excited I'm always excited to talk about blockchain and metaverse topics. I'm very excited about the space and have been working in the blockchain space since about 2016. And what makes it so much fun for me is that I started my career at the SEC, or very early in my career. I was in the SEC for a flash of a minute. And I also started just before the World Wide Web launched or was invented. And so there were bulletin board companies then, and I started working with early stage companies back then and have been very involved in internet and internet companies, internet innovation since then. And the way I see Web3 is as a continuation of the internet. And the analogies back to the internet are really unbelievable. Back to the Web1 internet in particular, not as much Web2. But if you think about it, Web1 was really the ability to read, and Web2 was the ability to write or to self-publish. And Web3 is the ability to own. So each time a new version of the web has come out or has evolved, it has grown exponentially larger. So I think this is the biggest one we're going to see, we've seen yet, because it involves pretty much ownership of all things. And so that begins with ownership of intellectual property assets and digital assets, which is what everyone in Web3 is excited to talk about. And also Metaverse, this is also where the convergence with the Metaverse is. So I'm very excited to be on the call. And I should also say that I have a entertainment practice, and that's something that made Steve and I really vibe, because I started as a young entertainment lawyer in the early 90s, working with the bands of that time, and also with the early internet startups in the music space of that time. So I've worked with a really wide variety of music tech companies, from the download era to the mobile era, which was a very sort of transformative era for music rights. I was sort of ballyhooed as a copyleft person for some reason by the music industry in the late 90s, which makes absolutely no sense because I'm totally capitalistic. But
Well, it's because you're so easy to talk to. I think one of the biggest things about Steve is he's accessible, right? And a lot of people go, "Oh, lawyer, I'm not gonna, I don't want to ask anything, and they might charge me, or they might be, just stuffy in general." But you're not. You're completely accessible. You speak straight across, right? You're not talking to legalese. You're able to break down very complex legal concepts into understandable language, which I think I appreciate, most artists I know appreciate, and probably everybody appreciates, because at some point we've all been connected with lawyers that have just talked above us, or quite frankly, in hindsight, I realized a lot of them didn't know what they were talking about because they couldn't explain it in layman's terms, which I think if you can do that with any subject, it shows your depth of knowledge and the ability to actually understand basic concepts. Because I think if you just keep things out of people's reach and don't let them have complete access or understanding, you may not have complete access or understanding of it. But kudos to you for being easy to talk to and accessible and a wealth of knowledge. And I got to say this, Steve moderated our legal panel at Futureworlds a couple months back and brought up probably the best tidbit. And I've quoted you maybe 10 times in the last month, but it was regarding smart contracts. And he said he did a lot of research and realized that smart contracts were not being written by attorneys, and they were being written by engineers and tech guys as part of coding, especially with regards to NFTs. And it made me think, that's pretty incredible. You've got guys that are coders or software developers structuring IP rights contracts digitally inside these contracts that may live with these NFTs or other pieces of digital assets forever. And no one's auditing them, no one's regulating them. They don't even understand the basics when it comes down to IP, which is something like yourself is an expert in. So it was shocking to hear you say that, but it's very true. I mean, everybody's touting smart contracts and smart contract this and smart contract that. Which lawyers have been drafting smart contracts?
Right. It's interesting. Also, the term smart contract is interesting because from a programmer's perspective, it's really a rule set for distributing whatever is being distributed, oftentimes money. And so from that perspective, it's very clear it doesn't need a lawyer. But legal contracts are a little different, and they have really fuzzier logic. And so as we evolve, as smart contracts evolve, it's going to become more nuanced and more difficult. And I think this is sort of this undiscussed section. Lawyers are aware of it. Everyone sort of presumes that a smart contract drafting business will emerge from this for lawyers, but I don't think it's emerged yet. And that also just tells you that the smart contracts that are drafted now have by definition have to be pretty rudimentary. Like just splitting $1 into 15 different ways for 15 different rights holders type thing.
It's also not accessible, right? And I would argue, I'm sure you could argue too, but one, a contract has to be agreed upon by both parties or multiple parties that are entering into it. If it's not even evident how to access it, in other words, I can't even read the language or the code that's inherent in that contract, how could I ever agree to it, right? And is there an implicit agreement when I buy an NFT? Did I sign something that says I'm accepting the terms of the smart contract? Not in anything I've ever seen so far.
Right. So, it's the early days, and I think these issues are coming up in the Bored Ape lawsuit. They're coming up there. They're going to come up in more lawsuits. But I think the tipping point was Sean Green, who purchased a Bored Ape and then tried to build a TV show around it, only to find out that he didn't actually have those rights. And I think the reason I think it was the tipping point is that it was a big news story at the time, even though probably nobody remembers it now. But I think that gave everybody who bought a Bored Ape pause to consider what they had actually purchased. I guess I bought a pixelated picture from the internet. And that really is what was bought. I mean, you do own that, and there's only one of what you bought, but the rights that go along with it are in question. And I think that the trade sort of blew up around NFTs before anyone even really deeply considered those rights issues about who actually owns the rest of the bundle of intellectual property rights associated with their NFTs.
I think it was Seth Green, but it was
Seth Green. Sorry.
You're right. It was. I remember that being touted as one of the value props for Bored Ape specifically was you had the rights to commercialize it, right? And I dug a little deeper. I think they do provide a commercial license, which is different than owning copyright. And there is no copyright transfer from what I could see. Like they reserve the copyright for themselves, but they allow you a commercial use. Now, what is that use? How long is it good for? Et cetera, et cetera, et cetera.
It looks like you did read the terms and conditions.
I read stuff. I mean, I'm a music manager. So it takes an additional 10, 15 minutes. And a lot of it is obscure. Like you say, you've got to go layer to layer to layer, but the public is paying $200, $300, $400, $1 million for Bored Ape, right? I mean, I think the cheapest one now is down to 200,000. It's a lot of money. You should understand what it is that you're buying, and more so, the platform should explain explicitly what you're buying, because otherwise, like you said, it's a muddled mess, and someone buys one anticipating they can create a show or some other content from it, finds out they can't, or there's some limitation, and then you get in this legal mess where I thought I bought something. Okay, well, how did you know this? Oh, well, here it is in our terms of service. Did you read that? No, but you signed that you read it and you accepted the product and you paid the money. So you're right. I think there's going to be a shakeout where a lot of folks are going to be unhappily surprised. A lot of platforms are either going to have to go back and redo those contracts or those terms and come to some type of agreement. If you've spent a couple $1 million on something, the lawyers are for sure going to circle, right? I mean, there's enough there. There's enough meat on that bone that a lawyer is going to jump on that and say, "Let me defend you on this." But I don't know that some of those cases have come to decisions yet. I know they're brewing. Have you seen? You haven't seen any decisions on this, right?
No. Yeah. Two things I wanted to say about it. It's one is, like I said before, it's early days, and a lot of it is a communications issue. So I spend a lot of time with people who are in the blockchain space, with crypto people, and also a lot of time with entertainment people. Many of the people at Futureworlds were sophisticated entertainment people who were completely shocked by these rights issues with NFTs, and they were completely shocked. I mean, sort of jaw drop level shocked that OpenSea would sort of bait and switch everybody and say, "Oh yeah, we said that you got rights with your NFTs, but actually you don't." Now, okay, move over to the crypto crew and talking to the blockchain people about it. They didn't understand why that would cause people to get bent out of shape. And so they legitimately don't know why that would annoy an entertainment industry person or anger an entertainment industry person who feels like they're getting ripped off, because from their perspective, they're just looking at this digital asset as a tradable thing, and they're not thinking about further exploitation of it, or making a television show like Seth Green wanted to do, or any of those aspects of it. They're just looking at it for the trading value, and that's the crypto people. And then the blockchain digital asset people are thinking, well, the normal person isn't really buying this for the IP rights, are they? And that's a conversation we have to have. No, I don't think they really are, but the entertainment people think they are. So it's a conversation. It's a conversation that hasn't happened yet, and these things come up so quickly that, and this is my next point, these things come up so quickly that you don't have time to have these conversations. It's already been a thing and then gone its way. Before anybody's ever talked about it, the law moves a lot more slowly than that. So two ways to think about it. One is lawsuits, the way you brought it up, is the incentive of litigators to find clients with a valuable claim to bring, or clients to find a litigator who is willing to represent their valuable claim. Very slow process. Most of the time, a lawyer's not taking this on contingency unless it's very large and not very risky. Nobody wants to do 50, 100, 150 hours worth of work to get nothing. So when people say, "Oh, I'll just take this guy to court on contingency," okay, well, find the lawyer who wants to do that. You're gonna have to sell it to them first. Then, okay, if you're paying some or all of their legal fees up front, well, now the burden's on you to pay some giant legal fees to bring these claims. What does that amount to? Well, I often say that it's $5,000. How mad are you, Steve? Are you $5,000 mad? Are you $20,000 mad? Or are you $250,000 mad? Go to your bank account and come back to me with that answer before I start calling my litigator friends.
I've been there. There's two things I would say to your point, though. It's one, whoever does the first one of these cases that has any kind of success at all is going to get more press than anybody else. I mean, forever, right? Someone's going to go, Stephen Masur took on the NFTs and won. oh, I got an NFT, I'm calling Steve, right? So
Yeah.
you've now built your business
Right.
on one successful case, which is what most contingency lawyers are looking for, is how do I get more business, right? I'm going to make money on this for sure. Maybe what's a risk? That's why I'm doing it on contingency. Or I'm going to get publicity, or I'm going to get stature based on me being that guy, the Shapiro, or pick an attorney that gets, high primetime TV ratings. And two, class actions, right? So if there are 10,000 NFT owners of that Bored Ape or whatever, and you get one of them to come on board at a case that you think is winnable, and you say, hey, wow, this is going to be a class action. Everybody else have Bored Ape? Come this way, right? All of a sudden, you've got 10,000 clients that may be on that same train. So,
Funny you would mention that. There was, again, it's fun to have been in this industry for a long time. There was that situation, and it was when I don't want to, make it too hyperbolic, but when the government was suing individual users for downloading music.
yeah.
So, some college kid downloaded some music, and suddenly he had a nasty letter in his mailbox. That was a lot of people. So there's a lawyer that I became very good friends with who took all those claims, and was very, very good. He was the perfect guy for those claims. Somebody who was not, who was very driven by morality, really, and really felt that these people were being wrongly accused. And that's what really turned him on. It's why he became a lawyer. He was an older lawyer, and somebody who had done a lot of human rights work and a lot of work, in the 60s, defending people's rights who were wrongly accused. And so he really dug his teeth into this thing. He had no fear of the major labels or of the law firms the major labels brought, and was willing to spend an unlimited amount of time to defend these people's rights, because it really got his goat that anybody would go after normal people for listening to music. So you're right, those people exist, and the lawsuits will come.
Was this guy, he was based in New York?
Yes.
I may know him. So there's the first kid that went down, he went to jail for downloading music. I can't remember his name. I was part of a documentary, and I was producing it with Ron Handler and Michael Austin. And I flew to New York. I hired a camera guy, and this kid was a trader, and I can't remember his name. What's his name? And I said, can I follow you to your house? I want to get a sense of your neighborhood, see where you live. He goes, you can come to my street, but I'm not going to let you show my house. Like, all right. So I hop on the Long Island Railroad with him out of Manhattan. I can't believe I'm getting an interview on the train, right? It's a subway train.
Right.
But the audio was so good. It was so, the guy had like a shotgun or whatever. It was a very directed microphone. And it was shocking to me that the audio came out so good. But this kid was so arrogant, and he goes, and he was convicted, and he had not been sentenced yet. And he goes, I'm not going to go to jail. There's no way I'm going to jail. They're going to give me probation. And I can't, so we walked down the street. I go, is there like a shop here that we could just sit down and I could talk to you? He's like, oh, this shop. I said, all right. And I go, your parents live here, right? He goes, yeah. I go, you have a little brother, right? Yeah. You're going to go to jail, right? If you go to jail for 2 or 4 years, what are they going to think about you? I mean, I hit every angle I could get to try to get the guy to connect on an emotional level. He was like, there's no way I'm going to jail. There's no way anything's happening to me. I'm going to appeal this if I lose. He just kept going on. I said, you're going to be sentenced in 10 days. And he just was so arrogant. And he had a DJ server, and he was sharing, he and a bunch of guys, and all the other guys pled guilty and just took the fine or whatever. He was the guy that said, you're not going to get me for this. And he ended up getting sentenced to, I think it was 2.5 years at the Manhattan Correctional Facility, whatever that thing is.
Oh, the Tombs is what it's called.
Yeah. It was the real jail. Yeah. And I kept in touch with him, and he got Barry Gittarts. That was his name. Wow, I didn't remember that.
Wow,
Barry
that's
Gittarts. Great. He got out, and I'm
failing to remember the lawyer's name. It's driving me crazy.
It was his lawyer, and I talked to his lawyer. Same thing. The guy's like, look, I tried to help him. He hurt himself every step of the way. And he said it is a violation. It was flagrant. It was not like, they sent a cease and desist and this kid just goes, oh, I'm sorry. He continued to do this, and he was doing it in the face of everybody, and the court just threw the book at him. But he was the first person to go to jail to be prosecuted with prison time for stealing, sharing files of music.
Terrible.
guitars. He's only probably 30 years old now, 35. But he lost all of his. He had a Series 7, Series 63, all these trading licenses gone because he's a felon. Right? Wow. It was a felony conviction, and that's why he went down to jail. And but yeah, to your point, it was shocking to see how far the RIAA especially would go after listeners. I mean, they were arresting mothers and school teachers and people that just were listening to music without an intent to commercialize it or make a profit from it, which I understand the basics of copyright doesn't necessarily mean you have to have an intent to make a profit, right? You can do something with zero money and still be infringing.
Yeah.
But you're right. Communication wise, the public doesn't know that, right? They don't know the difference between a copyright infringement and listening to some music that someone gave them or shared with them. So I think you're right. Education's a big part of it. I think that there's got to be some standardization with regard to NFTs, especially, but anything in the Web3 or the digital space where the public is becoming more entrenched in the usage of the music, in the creation of other content with that music, a la YouTube, right? I mean, YouTube was basically formed on music videos. People just made a video and thought, I got to put some music to it. And they pick up the best song they knew and stick it on. And YouTube was sold to Google as probably the biggest copyright infringing website there ever was, right? I mean, Google bought it for $5 billion and started to clean it up a little bit. You got the digital.
You're on my soapbox. I'm loving it. Keep going.
Right? But you've seen it. They would rather make it's tech, like you said. They'd rather jump in and get arrested or get slapped on the wrist than try to figure out all the legal stuff beforehand. Because, like you also mentioned, the law is always behind the tech, right? Legal stuff and litigation always trails by, I'm going to say 3 to 5 years, right? Yeah. So the tech guys Uber is a great example, right?
Uber's always my other example of that. Right? They were. I'm lucky and blessed to be early to many of these things. So there was a company actually created by Alex Mashinsky, a well-known person in the Web3 space, called Metrolink. Metrolink was the same thing as Uber. And a prior company called Celluride, same thing as Uber, pitched to me in 2006, long before Uber. And the person who made Celluride actually was sort of a study carrel mate at the incubator. His name is Kevin Halpern, and he was a study carrel, sort of a mentor-mentee relationship with oh shoot, I'm forgetting his name too, Mr. Red Swoosh, the Travis Kalanick.
Oh, Kalanick, yeah.
And I mean, without putting too fine a point on it, Travis just ripped him off and took the idea, went to the VCs. They know who they are, a couple of big ones, and kind of said, well, we don't know about Kevin as a CEO, but we know that you, Travis, could be a good CEO for this, so we're going to make you a CEO of it. And Uber was born. And every single person, including Uber, who pitched me on this, I just looked at it and I always said the same thing. You're not going to get this past the New York City Cab and Limousine Commission, much less every single other similar organization in the country and world. Well, guess what? I was completely wrong about that. So it is true that innovation can trump the law, but there are consequences. And I think we're going to see a lot of that in Web3 too. And the other point I wanted to make, which actually does tie all this up in a bow, is regulation. The regulation in the blockchain space has been unclear for quite a long time. I mean, if you think of Bitcoin as starting in 2010, and well, now it's 2013, and we still don't know if a
2023.
2023, I'm sorry, and we still don't know if a token is a security yet. And it still stops anyone from selling tokens in the US because they're afraid the SEC is going to come after them if each and every one of these tokens is actually a security. My feeling is that the tokens can be programmed to do a lot of things. So some of them might look like securities, some might look like commodities and would be regulated by the CFTC. Others are neither of those things. The regulation is just as slow as the litigation. So we didn't see claims against ICOs and token launches until about 5 years later, which is actually pretty fast. We are only now seeing the claims against NFTs. And at the beginning of tokens, everyone said the law doesn't apply, so we can do what we want. At the beginning of NFTs, everyone said the law doesn't apply, so we can do what we want. We've established, they would say, that these are not securities. Well, I mean, it's a test, so some are and some aren't. Probably most are not in the NFT space, but there are NFTs that are securities or that would fit the qualification of being a security. It's a fuzzy test, the Howey test. So if you took your typical music royalty, that might look like a security too. And it might actually fit the Howey test, percentage payments, not considered securities. Okay, now we're in the DAO world. For the last year or two, people have been shopping DAOs and getting people to buy into DAOs. I'm very excited about DAOs and the possibilities of this new structure of corporate governance. It's very exciting to me. We're doing a lot of work in the space. But the DAO interests are being sold as if they're not securities. So maybe they are, maybe they're not. We're not going to know for 5 years. And so the problem is the evidence is there. The evidence against your guy who got prosecuted was there and can't be taken away. So my word to people is simply be aware of what you're doing today, knowing that the evidence will be there 5 years from now, when whoever it is, the SEC, the DOJ, the CFTC comes searching. Now, I'm going to sort of soften that by saying that they're not really looking for you, they're looking for fraudsters. Think about a young up and coming securities enforcement lawyer who is researching something. Is she going to research a company that made a few $1,000s and didn't win, or is she going to research Bored Ape Yacht Club? Probably Bored Ape Yacht Club. And so a lot of times, if you get that nasty letter, they're probably looking for somebody else, but or somebody who really ripped somebody off intentionally and with malice aforethought, to use a funny legal expression that doesn't apply here. So that's the way to think.
Well, I've always said the SEC, their mandate is to protect the mom and pops, right? Their mandate is to protect people that don't know any better and don't have the resources to fight for themselves. At least that's my take on it. If you're a big corporation, if you're accredited, if you're savvy, they're like, fend for yourself. But if you're the general public, you're somebody who's an 85-year-old retiree and this is your nest egg and you put it into some thing that was a security and that went away, that's who they're out there to protect. And a lot of these things, even the penalties that I've seen are just slaps on the wrist. And the players know this, right? So the YouTubes and the Googles, they know, hey, what's the worst exposure that could happen, right? They hit us with a $10 million fine. $10 million we made yesterday, right? Profit just from YouTube. Okay, let's take that risk and run because we're making $100 million every day. So when the $10 million penalty comes in 5 years, okay. The other thing is,
well, YouTube was not making $100 million a day at the beginning, and they had to overcome. So your typical startup entrepreneurs in those shoes. But Google, I don't know.
Google was, and they said, we can absorb this, right? We are very well aware this is nothing but an infringement engine. Even if it is, we have the political wherewithal, and I'll go to the DCIMA or every, what's it,
DCMA, yeah. This
DCMA.
is, Google did acquire them, and after the acquisition, that was true. But new law was created from that, the DMCA.
Yes.
Notice and takedown provisions.
But my argument would be that Google influenced that law and
yes,
had lobbyists on board to help create and draft that law. So they knew the worst exposure is X. If we can mitigate that by hiring a bunch of lobbyists and supporting and paying, bribing the powers that be to say, hey, let's legislate this way, allowing a backdoor takedown provision, right, which puts them off the hook, basically. Now, okay, we thought it was a $1 billion liability. Now it's $100 million liability. Okay, boom, right? They were big enough to absorb that. Just like the automakers, the aircraft manufacturers, everybody else that has a lot of potentially high litigation costs, but they can also mitigate by making political donations or hiring a panel of lobbyists, a la Facebook, Google, Apple, you name it, right? That's
right.
That's how this game works.
Right, but our audience here today probably may or may not have access to those kinds of funds and that kind of capital. And my guess is those people are pretty well represented and are getting that advice from someone. I think we should give people advice, news they can use today. And so
that's a good point.
My point is, don't not do NFTs, to be Laird Hamilton-esque about this. I don't want to live because of my fear of dying, right? Do it, innovate, do the stuff, and just be aware of what you're doing and be aware that the evidence will be there later. And but that innovation can win.
So there's 2 points that when you're saying that I thought of. One, it's like the cannabis laws, right? There are people in jail, literally in jail today, for things that were illegal 5 years ago that are now completely legal, right? So if you're selling,
it makes me angry every day, Steve. Every day it makes me angry.
But that's true, right?
People are doing jail time for selling cannabis when now almost no state is serious about enforcing those laws.
That's what I'm saying. So something that was highly prosecuted 5 years ago is now basically ignored. And so in relating this to NFTs specifically, if there's something that you're on the edge about that might be red flagged quickly today, 5 years from now, maybe that's completely okay. So my ethos is try to do what's right, obviously, disclose as much as you can, because what I've learned from reading SEC stuff, and you're former SEC, but if you make every attempt to disclose to the investor, the consumer, the buyer, everything you can about what it is they're getting, right? And you do everything you can to be transparent about, here's how this works, here's how this works, this is what the offering is, even if the rules are unclear, which they are right now. They are very unclear. Like you said, is it a security? This guy says yes, this ruling says no. It's like, which is it, right? And there are different types of tokens. Like you said, tokens, an NFT is a non-fungible token. That can represent anything. It's literally a piece of code. What you attach to that code signifies what that NFT is. People look at an NFT as a collectible piece of digital art usually today, which it isn't always that. It could be an audio file, could be just a piece of code, right? It could be a token, for an exchangeable token. But there's no set definition of what it is. If you do your best to disclose, to be transparent, when that regulation comes in, and it will, they're going to look at, like you said, how much effort did this person make to do the right thing, right? Were they trying to be a fraudster? Were they trying to do a one-off scam and take the money and run, a rug pull as they call it today? Or did they make every effort? Did they hire attorneys? Did they research it? Did they disclose, right? If they see that, my feeling is they're going to go a little more lenient on someone that's made every effort, hired attorneys, did their best to do what it was.
Absolutely true. It's, the case law, they're speaking to us through the case law.
Yes.
There are only 4,000 of them. They can't really prosecute everybody. So What they do is they find a couple of big ones to take down, and they talk to us through them. So one of those cases is Munchie. It's a Howey test case about what is a security or what is not a security, and what you can do with securities. And without going into the facts of it, they found that the Munchie people had been distributing securities without disclosing the information about them to the SEC. These are the sunshine laws. So your point about disclosure is super important. Yes, disclose what you're doing. It's a lot harder to argue that you were trying to rip somebody off if you told them everything beforehand. And back to Munchie, their penalty was basically, they said, okay, guys, foul, you did the wrong thing. Why don't you give the money back? And then we probably won't do anything else. So that's them speaking to us, saying exactly what you just said, that if you're trying to do the right thing, they may call foul on you even then, but they're probably not going to, give you jail time. They may just ask you to give the money back.
Yeah, they're not, to me, they're not the big ogres. In fact, I think they're playing catch up 90% of the time. They are trying to, I know they're talking to industry to try to help draft the guidelines and regulations, because they don't even know the space, right? They're lawyers, most of them, and they come in and go, tell us how we can legislate. How can we craft regulation around what's real? Because they don't even know what's real, right? Give us the state of the art. Tell us where the holes are. Let's see if we can make this something that makes sense for the general public. Again, it's, if you're an institutional investor, it doesn't apply to you. If you're, big, Fortune 100 company, doesn't apply to you really, except on the other side. Although, you see guys like this Sam Bankman-Fried thing, which is just crazy, where there's a kid that I think was pushing every limit he could. I don't think he was benign. I don't think he didn't know anything. I think he was smart enough and had underlings that did things that maybe on his behest or not his behest, but
what he has frankly, it has nothing to do with blockchain technology.
Nothing.
Other than that, the assets that he was using to steal money from people were blockchain assets. That was a centralized exchange, which is not a DEX or a decentralized exchange. And basically, there's the phrase, not your keys, not your crypto. And what it means is, if you give somebody else your keys, it's their crypto. That's the positive way of saying it. And everybody who invested in FTX gave SBF their key, and then he took all the money and invested it somewhere else and lost it. So that isn't a crypto problem. That's just straight up fraud.
Straight up. And you're right. People conflate it with blockchain, with Bitcoin. I'm like, no. It's got nothing to do with crypto at all. It's an exchange issue. It's as if your Bank of America took all the money out of the bank accounts and put it in some weird investment, and you couldn't get it anymore.
Identical.
It's got nothing to do with the value of the dollar has got nothing to do with Bank of America. But this guy was running an exchange more deeply connected than I thought. I mean, you're seeing stuff still come out going, wow, look at Binance. Maybe there's exposure, right? Look at crypto.com, whatever. There's a couple other players that had some exposure. I think there's due to be shakeouts, and hopefully this was a good warning to those that didn't really do due diligence. I know a lot of money was spread amongst, again, a lot of politicians. He's got lobbyists on both sides that are protecting him, and we'll see what happens with that stuff. But it's shocking, the lack of due diligence on even the investment side, right? I mean, he had to have
that's
millions
just
of dollars in
crazy because of the many clients I've represented in venture capital deals. We do a lot of venture capital deals, and they ask our clients all those questions. I mean, it's a proctology exam like you've never seen for our clients that are smaller companies. I don't know how.
I've been there. Yeah.
Managed to walk through that with no questions being asked.
Yeah, where's the audit? Where's the Deloitte audit, right? I mean, it's you're talking about hundreds of millions, even into the billions of dollars. You think they'd be audited by a Deloitte or a Ernst and Young or somebody, and if they were, where are the red flags? Right? No controls, offshore. It just Yeah. So yeah, hopefully that just brings in proper regulation, proper disclosures. It opens the market up legitimately. Um, I don't know that it needs to slow any growth, but it will make people aware of what they're buying and what they're transacting and building. Um, and I back to the first point where the smart contracts aren't being written by lawyers. People need to understand that IP is a big part of these transactions. Right?
Yeah.
From NBA Top Shots down to Bored Apes, yeah, people thought they bought this video clip and they're like, "Oh, I'm going to put that on my TV show." It's like, no, you're not. Right? You basically bought a recording with personal consumption rights. That's kind of it. And I think it was I shouldn't say it's pretty explicit. It was in the fine print because I read some of the fine print. But again, you're offering something that looks like a video clip for sale. And you're going to pay 10 grand for a video clip. I better be able to play that wherever I want. I better be able to use that. But like you said, there are limits. And I think the concept of ownership is something that people need to be educated on, because I can't even define it in all instances. You buy a CD back in the day, or you buy a vinyl record today. Do you own that song?
Well, all of this is consistent with what I would call crypto ethics or blockchain ethics. The whole idea is transparency and immutability. So the rights issues, technically on a very high level, blockchain should solve all music rights issues, all content rights issues. That's what the purpose of the technology is to provide a clear record of provenance and transparency and the ability to pay in a trustless environment. So now we're at, NFTs, nobody knew what those were. I guess we needed to go through that whole NFT trading cycle. Now everyone knows what they are. And in fact, they're going to get a new name called digital assets so that it doesn't obfuscate what's going on. And digital assets, the rights issues, back to smart contracts, are going to be coded into them. And it's going to extend beyond digital assets to physical assets, and already is extending to real estate and to cars and to your mobile phone. It's good. There's just a lot of growth. We're very early in the cycle of that. And the crazy things that happen in the early market are happening. So it's an exciting time, I think.
So I got to ask you one more question. We're pretty close to the end of the hour here, but it's just, I see this every single day. Where do you think the impact of Chat GPT is on the legal industry?
On what?
On the legal industry. So in my history with lawyers, and I've probably hired 100 lawyers without exaggeration, 90% of the work is templates.
Thank you.
Right? I'm not saying they're not good people, they're not good lawyers, or they don't do good work, but honestly, right? If you're drafting a record contract, you're not going to go, okay, where's my blank sheet of paper and let's start. You take a template for a record label contract and you say, okay, I'm going to change this word, that, and you change all the terms, you make it work, and then you spit it out.
Benefit and a flaw. I mean, the fact that we look to precedent is a benefit because we build on what was built before. Every record deal is not the same, but a lot of the record deal is the same. And yeah, you're right. We take the template and then we adapt it to the situation. And there's a lot of legal work involved in that. I don't think I can't really speak for all lawyers, but I think most lawyers don't really want to just make money on rinse repeat. I think most lawyers want to be creative and add value in addition to what is already in the form. And when something does become templatized, we're overjoyed. I certainly in our practice, we've always attempted to take that model and apply it to our businesses. If it's a music licensing business, we would create one license and then come back 6 months later and ask, what were the clauses in here which were problematic to people? We'll knock the corners off of those so you don't have to come back to us again, and you're only coming to us for the big stuff. That's the way most lawyers think about it. So that's the benefit of the templates. The problem with the templates and with precedent level thinking, generally speaking, is that when you do actually have something new, the lawyers are always looking for a precedent, and they don't know what to do. You ask them what to do and they don't know what to do. And they just tell you the law over and over again. And the complaints you were making at the beginning of our podcast are what it feels like to you when the lawyer doesn't know what you're talking about and doesn't know how to handle it and doesn't know which template to use. And it takes an unusual and creative lawyer to sit down with a blank page. With our associates and our interns, I usually will tell them to do that. Just do the exercise, sit down with a blank page and write the contract from scratch, because there's so much terrible legal drafting involved in adapting one thing to the other. And this is where the language of legalese came from. I mean, we should be writing these contracts in the English language if we're writing for an English speaking country. That's how it should be. And lawyers who have written a contract from scratch, you learn so much from it. It's just an incredible exercise. It's like, and I would suggest to every American, read the Constitution. It's 33 pages long. You can do it. It's the same kind of thing. You learn so much from these simple exercises. So yeah, I think that automation and AI is going to affect the legal industry, but I think it'll affect it in a good way. The same way that we don't use mimeographs and copies, and we don't use bike messengers to get our stuff, or mail or gas to get our information around anymore.
No, you hit it on the head. I think in the first two sentences, you said it will take the creative part and make that your focus versus the menial templated part, right? So
yeah.
If AI handles all the menial stuff, it says, look, all the jargon on, claims and where do I send a notice, all the, the boilerplate stuff. And you can now focus on the terms and really, how does this relationship or agreement work? How does this play upon this? Those are the things that maybe the AI can't figure out because it isn't written somewhere, right? You have to take the elements specific to that contract and integrate them in your mind. Maybe AI gets there at some point, but that's really where the meat of your time and where your value is, I think, not in, hey, can you write like a legal, disclosure at the end of it? Like that's just boilerplate. So I'm with you. I think that the AI, if it can help you do less menial and more creative work, in other words, getting to the meat of the value, then it's helpful. But this tool it'll spit out. I mean, it's able to scan the vast internet for information, precedent, other cases, other opinions, and put it down succinctly in a matter of seconds, right? And it could be completely wrong, but I'm not saying it's not a bad place to start, right? If it gave you a block like this and you had to hone it down and whittle it down to make it the right way you want it, polished, there's value to that versus I got to start at
absolutely
zero.
There is. And the writers tools now do that as well. And writers are using those. Lawyers have not really started to adopt those yet, but it's all coming. And before the end of the hour, I should just go back to where does the copyright law come from? Well, the copyright clause in the Constitution is one sentence or one clause and short, and it's a balancing test. It doesn't say that you get to own everything. It says that you should be able to profit from building upon what other people have built so that we have progress, and progress continues to happen. And
that's a very good point. Most people don't get that. They think
Yeah.
it's only about protecting a specific owner, but
Yes.
in reality, it's about bringing in all ideas, giving you a period of time in which there's some protection so you can hone that out and flesh it out, and then letting other people take that idea and build upon it, which is a completely different concept from I own it forever, see you later.
Which and there's so many analogs to what coders do and what lawyers do, very similar in code. where you have componentware that somebody built 10 years ago, and you just use that because that's what everybody uses, and then you use your creative part is the new thing. And that's what we should do as attorneys. I just want to draw some analogies.
Go for it.
Web 1, Web 3 analogies. My favorite one is Facebook, Meta. Meta is AOL, pretty much exactly the same as AOL. A walled garden that nobody wants to play in because they'd rather play on the open internet. It's very similar, and metaverses are very similar to the early open internet, in that everyone thinks they haven't seen a metaverse, but they're looking at the metaverse every day through their mobile phone and their computer screen. And right now we're talking on a metaverse, and there are hundreds of metaverses. And it's just that they aren't necessarily all fully immersive VR metaverses. And so that is what's happening in Web3. It's a new evolution of the internet that will not be all that easy to predict, other than to say that what I said at the beginning is true. It's ownership now. So think about that as an entrepreneur, as an artist. How do I capitalize on my ownership? And there's also a pendulum situation happening here. It's the old client-server pendulum. Should we have more power on the computer that's in your hand, or should we have more power in the cloud? And it's this very similar pendulum swing situation now that we have to look at with Web3, where we have all moved in the music space anyway. We've moved to Spotify and SoundCloud and other streaming services. Well, that is housing the data in the cloud and accessing the data so that these download issues that we talked about are not a problem anymore. And normal users who are only going to listen get a Spotify account, and they can listen to anything they want. That is, almost completely on the cloud side and not the client side. Music NFTs that people sell, that's swinging back to the owning this piece of digital asset that sits on my computer and I get to listen to it and nobody else does. That's a completely different model. And we have to really think about how in the next 5 years or however long those models will develop.
You're one of the first people to actually say that, because I've thought the same thing. It's like we are swinging back to CDs, right? When you're buying NFT, that's like buying a download. That's like Apple iTunes circa 2015, right? I mean, that was that model, which, by the way, has a huge amount of profit margin compared to a stream. And now that you could package in other elements with that NFT, maybe it works as a ticket, maybe it works as a piece of digital art, what have you, there is an opportunity to jack that price up, right? So instead of I bought it for $10, maybe I bought it for $1,000 because it includes admission to this.
Yeah, you're jacking the price up by adding value.
Correct. Which is different than a CD or a piece of vinyl, 100%. And it's being done.
CD-ROM boom?
What's
the CD-ROM boom that preceded the internet boom?
Yes. Well, and it's also being done, to your point, by the creator more than a third party now, right? So if I don't have a label, I'm writing some music and I want to put it out on NFTs, I can control that spigot. I don't have to have Apple iTunes in the middle or anybody or Atlantic Records in the middle. I can do that myself. So I was going to mention the other thing besides ownership with Web3 to me is the creator consumer blur, right? You are now consuming and potentially creating at the same time. I could be a musical artist that's buying a visual piece of art, but I'm creating audio art on my side, and someone else is going to use my audio art and be a consumer of that and put it in their project, right? So instead of just being a flat wall between retail creators and consumers, that's starting to blend, where many times I'm creating something, but I'm also consuming. And again, back to your point, the ownership stake in that is, I think, what's going to drive that economy, where you're not getting that in Web 2 and Web 1, where Facebook and Google and everybody owns, those companies own those things. You can play in their playground, It's like Roblox, right? You could go play on Roblox, you could buy digital skins on Roblox, but that economy is kind of off on their side. Whereas if you go into Decentraland or Sandbox, you can create that economy, you can create those digital goods and own them and control those sales and commission those sales and sell your property, rent your property, build your property, develop it. That's on you versus playing in someone else's world where they're benefiting from your attention. They're running ads against you being there, et cetera, et cetera, et cetera. So I think that's one of the big changes also. But ownership to me it's the bottom line in that difference.
Yep, and ownership of your own personal data. Hopefully we will get to a point where we own our personal data and can meter it out.
100%. Steve, thanks so much for hopping on. Always a good conversation. I know we could talk about this for another 5 years, which we will.
We certainly will.
But I look forward to seeing you very soon. I'm going to call you next time I'm in New York.
Okay, thank you. Have a good rest of your afternoon.
Okay,
and thank you for having me.
Of course, anytime. Talk to you soon, Steve. Bye-bye.